Hello guys, and welcome to another episode of my lecture. On today's episode, we'll be talking about types of admission. In my previous lecture, we defined what exactly admission is. We looked at the nature of admissions, and in this particular lecture, we'll be talking about the types. So what exactly are the types? Let us go to my notes. Admissions may be formal and informal. Informal admissions are made out of courts, while formal admissions are those made in open court or in papers filed in court, which are taken as establishing the fact in issue without further proof. Section 123 of the Evidence Act deals with formal admission which need not be proved. Section 123 of the Evidence Act says, no fact needs to be proved in any civil matter which the parties to the proceeding or their agents agree to admit at the hearing, or which before the hearing they agree to admit by any writing under their hands, or which by any rule or pleading in force at the time they are deemed to have admitted by their pleadings. Also, informal admissions are oral and written admissions, as well as admissions by conduct as stated in section 20 of the Evidence Act. I know we discussed section 20 in my last lecture, but let us just mention it briefly again. An admission is a statement, oral or documentary, or conduct which suggests any inference as to any fact in issue or relevant fact, and which is made by any of the persons and in the circumstances mentioned in the act. So yes, here we are talking about four things: statement, oral, written, that's documentary, or by conduct. Those are the four ways by which you can have an admission. However, four ways and two types. What are the two types? Formal admission, as we can see in section 123. What are the formal admissions? Formal admissions are things that are done in court. We are not discussing formal admission in this lecture at all, because they are pretty straightforward. You've already kept it in your pleading. I mean, there's no other thing to prove, because once it's in your pleading or once it is stated verbally in court, then why are we proving any other thing? I mean, the other party against whom the admission is supposed to be adverse had already admitted to it. Why will I be proving something contrary and stuff like that? So our problem basically is on informal admissions. So when we are looking at informal admissions, we have to look at it from different perspectives. First of all, informal admission that could be a statement, informal admission that could be documentary, informal admission that could be by their conduct, and informal admission that could be oral. Those are the things that I'll be discussing in my next set of classes. But here, I just need you to understand that when you're talking about types of admission, there are two: formal and informal. Informal is the one that is done outside the courts. Do you understand? But what are the ways by which you can have an admission? Four ways: by statement, oral, or documentary, and by conduct. Four ways, but two types of admissions. Do you understand that? So in my next series of classes, we are going to be discussing by conduct, silence, and all that. But in my next class, I'll be discussing admission by conduct of the parties, whether or not it would be a valid admission. So I will see you in my next lecture.